This week on Lewis on the Law, I have yet another awesome and informative show for you. I have attorney Patricia Ammari, principal and founder of the Ammari Law Firm, and we're going to talk about issues that affect our aging populations.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week for the next 48 minutes. I have yet another exciting show for you. And, you know, here on Lewis on the Law, we bring you legal information and not legal advice. So if you have a serious legal issue, go ahead and contract with an attorney. I am so honored to have attorney Patricia Ammari on, and she's the principal attorney at the Ammari Law Firm. Hi, Patricia. How are you?
Hi, thank you so much for having me.
Oh, yeah, it's awesome. So this show is talking about elder law or issues that affect legal issues that affect our aging populations. What exactly do we mean by elder law?
So elder law is defined by the National Elder Law Foundation as counseling and representing older persons and persons with special needs regarding long-term care planning, public benefits, surrogate decision-making, legal capacity, and managing their estates. So it's a pretty broad topic, and it's actually a relatively new topic as well. It's only existed for the last couple of decades.
Yeah, it's a huge topic. I fielded a whole bunch of questions, and I threw several of them at you, and, you know, you're like, well, some of them fit in, some of them, and I'm just like, they're all kind of elder law questions, but that's because I don't really know. I'm principally a real estate attorney, so, you know, you have to forgive me these things.
Oh, absolutely, absolutely.
So we did have one question from a listener that we're going to go ahead and tackle here real quickly. So does her time on long-term disability count for 2 years before she receives Medicare after she's eligible for Social Security benefits?
Okay.
I'm not sure if I worded that correctly.
Sure.
It's convoluted.
So basically, I think what the listener is asking about is when you receive Social Security disability insurance, within 2 years of that, you are eligible to receive Medicare. So if you're determined disabled, younger than 65, then you might actually get Medicare sooner than others do. But you have to kind of look at the time periods. So first of all, there's an entitlement date, and that entitlement date for receiving the disability benefits is actually 5 months after the disability. So there's sort of a waiting period there. And then once you hit that entitlement date, then from there, there's a 2-year wait to receive Medicare. Now, for a lot of folks, if they were employed at the time, and they would be if they're receiving Social Security disability insurance, then they might get long-term disability insurance through their employer. And that is actually okay. That doesn't cut into that Medicare time, and that's a great way to pay for your bills while you're waiting pay for your medical care while you're waiting for that Medicare to kick in.
Okay. That sounds good. Thanks so much for that answer. And I hope, Sandy, that answers your question. If not, just hit me again and we'll go around again. So let's start this topic off. And I guess we want to start off with estate planning. Is that correct?
Absolutely. So today we're going to talk about estate planning, guardianships and conservatorships, and then long-term care if we get a chance. The hour goes by fast, I'm told.
It does go by really quickly.
So, but when we're talking about estate planning, what does that mean? Well, basically it means either a will or a trust, and then a power of attorney and an advance directive. And we'll talk a little bit about what each of those things mean. So a will basically allows you to determine who gets your assets when you die. It also allows you to name who it is that you want to manage your estate when you die and make sure that all the right people get those assets. And it also basically lets you set the rules for the administration of your estate. And so the will is important because it allows you to pass that wealth on. When you don't have a will, the state of Georgia has a plan for you. And some folks are kind of surprised as to what that plan might be. For example, if you're married and you have children, instead of everything going to the spouse actually shares with the children. If there are 2 children, for instance, the spouse would get a third, and each child would get a third. If there are more children, the spouse always at least gets that third. But for some folks, that's not exactly what they anticipate. So if you want your estate to pass in a different way, that's important that you have a will that sets that out. And then there's another option called a revocable living trust. And that option we call sometimes a will substitute. And that document does all the same things that a will does, but the other thing that that document does, which is pretty terrific, is it allows someone to step into your shoes to manage your property if ever you can't. And when you think about seniors, you're more likely to find yourself in that situation. And so basically what happens is, this document is created, then you have to transfer everything into this trust. We call it funding the trust. And once everything is in that trust, typically when we set it up, it's an agreement. And it's an agreement between you as the grantor, the person who creates the trust, and then the trustee, a trusted person. When you set up the trust, you're generally able to manage that property on your own, so you are your own trustee. But if ever you're not able to, you have named a successor trustee, and then that successor trustee can just begin managing that property for you when you're unable to do so.
Okay, so what are the benefits to having a revocable living trust as opposed to having a will?
So I think the biggest benefit, there are a few benefits. One is avoiding probate. And in Georgia, we're known as being a relatively friendly probate state. There are some states where it's very expensive and very time consuming, and everyone there has a revocable living trust. And we don't live in a state like that. But I do hear from a fair amount of folks who have been through the process. They'd really rather not go through it themselves or have their family members go through it with them. So that's one thing that it does. It can also offer some privacy. And for most folks, they're not too worried about that because they're leaving things to their spouse and their kids, and they really don't care who knows about that. But other folks really would like to have a little bit more privacy. So it can provide privacy. If you own property in another state, it's a really good idea because then you don't have to probate in multiple states. And then also managing property for folks as they age is another good reason when you might want to do that.
Okay, that sounds reasonable. Would you advise our listeners to have a financial power of attorney as they're growing older?
Absolutely. Everyone should have a financial power of attorney if you're over the age of 18 and you have a bank account.
Over the age of 18? That's hardly an elder person.
Well, that part of it really everyone should have, but it is an elder issue in that the provisions that I'm going to put for an 18-year-old are going to be different than the ones that I put in for seniors. Because as someone ages, they need to provide, they need to provide certain powers to their loved ones in case they would ever need a long-term care plan, which is something we'll talk about in another session. But basically what a power of attorney does is it allows you to name someone who can manage your property for you when you're not able to. And it's not 100%, but it's gotten better. There was a new wholesale law done in 2017 that it was a 37-page law that basically changed the law of powers of attorney in Georgia. Up until then, whenever I would do a power of attorney for a client, would always tell them they should have one. I'd have to tell them there's no law in Georgia that requires anyone to accept it. And that's actually no longer the case. Under certain circumstances, you can force an institution to accept the power of attorney. Now, there are exceptions, and it's not 100%. And the other problem is that it's a brand new law. And so we're still kind of seeing as to what the banks are going to do with it. And in Florida, they had to do some litigation before the banks would actually accept it. So we don't really know what that's going to look like here in Georgia yet. So it's a little bit of flux. But I do recommend that everyone consider redoing their power of attorney, because what we're concerned about is now that they have to take certain powers of attorney, they may realize, oh, I didn't actually have to accept that other one. So as those older power of attorneys continue to get older, I think it may be more likely that they're refused.
Okay, so it's the requirements itself for the power of attorney that have also changed?
There have been some changes, and they did some changes in 2017, and then they fixed some of those changes in 2018 because they didn't make a lot of sense. So it's sort of been in some flux, but there are some definite requirements now that have to be met when you're doing the power of attorney that we didn't quite have before. The law was just very murky with respect to that. So we've got some clarity, which is important.
Okay, have you actually had a lot of problems with financial institutions not accepting a power of attorney? Have you run across that yet?
So usually we're able to, what I always tell my clients when we do a power of attorney is I tell them to take the power of attorney to their bank now. Because if the bank receives it from them when they're competent, that does two things. First of all, it lets the bank know that yes, it came from the client and that they really do want them to honor this. But the second thing that it does is it gives the bank to object or say, we have a particular issue with this provision, or we'd like to see this additional thing in here. And if the bank lets them know that when they have capacity, then you could tweak it for them, to meet the bank's requirements if necessary. And now that we have the new law that requires them to accept it, in some cases we educate the bank on the new law and explain that no, you can't refuse to take it for those reasons that you might have refused to take it before.
Perfect. Okay, we're up against the end of this segment. Patricia, will you give them some contact information for you?
Absolutely. You can reach me at www.elderlawatlanta.com. So that's www.elderlawatlanta.com or 678-609-3230.
You're listening to Lewis on the Law. My show is designed to bring you legal information. It's not to replace the advice of an attorney. If you have a serious legal issue, contact an attorney. You can always contact me. A lot of attorneys come through this show, and I can always give you a recommendation if I can't handle your legal issue itself. All my old shows are archived on my website, jameslewislegal.com. So if you need your first step in any legal issue, just go to my website, listen to a show, kind of get your bearings, and then you can go from there. When we come back, we'll talk a little bit about advanced directives, guardianship, conservatorship. I'm not even quite sure what that is, but I'm sure I'm about to find out. You're listening to Lewis on the Law. You're listening to Lewis on the Law, and if you know the song that clip comes from, it's a good thing you're listening to this show. Actually, now I found out that even if you're 18 or over, you should still probably listen to this particular episode because there are issues that might affect you. And maybe there's lots of issues that affect you. When we left off, we were about to get into advanced directives. I'm here with attorney Patricia Ammari from the Ammari firm. And Patricia, one more time, give them some contact information for you.
Oh, absolutely. Thank you, James. Mm-hmm. It's www.elderlawatlanta.com. And the telephone number is 678-609-3230.
Okay, advanced directive. First, what is an advanced directive?
So you might know the term advanced directive through other terms, like a living will and a healthcare power of attorney. And that's what they used to be known as. But several years ago, the state of Georgia went ahead with a national trend and adopted a statute about advanced directives, and that's what they're called now. A lot of folks have heard that term when they go to the doctor or the hospital when they're asked, do you have an advanced directive? And so that's what an advanced directive is. And it lets you do three things. It lets you name a healthcare agent if ever you're not able to make decisions for yourself for your health care. The other thing that it does is it allows you to make some limited end-of-life decisions. So when I say limited, it's under a couple of circumstances. One, if you were ever to be in a permanent vegetative state. The other is if you have a terminal condition and you're about to die in a short period of time. So if you're out there jogging and you have a heart attack, that is not going to be covered by this advanced directive, this part of the advanced directive. And then the choices that you can make under those two very specific circumstances are that you would like everything to be done to keep you alive forever and ever and ever, as long as medical science can allow. The other is to let you die naturally. And then finally is sort of a pick and choose option. So it says that it is going to let you die naturally, except that you can have a ventilator or CPR or fluid by tube or feeding by tube. And so the vast majority of my clients typically choose B, which is to let me go naturally, because it's only under those very specific circumstances. And then the third thing that it allows you to do is to name a guardian if ever you would need one.
Now, guardianship is strange in this context because, I mean, maybe it's just me, but normally when I think of guardianship, I'm thinking of guardianship of children.
Exactly, and it's sort of a lot like that. So when someone turns 18, we automatically, give them the ability to be an adult, and that means that they have the legal capacity to make their own decisions, and their parents no longer do. So what guardianship does and conservatorship, guardianship is about the health side of it, and conservatorship is about the money side of it. It allows someone to be able to make decisions for someone when they're not able to make them decisions themselves. And there's a legal process that we go through in the probate court in order to be able to be named in that capacity.
Okay, is guardianship the exact same thing as conservatorship?
It's close. So, and that actually all used to go under the term guardianship.
Okay.
But a few years ago, we changed it a little bit and we gave the finance side of it the term conservatorship. And what a conservator does is it manages the property of someone who does not have legal capacity to do it for themselves. The guardian is the one who makes healthcare decisions and decides where someone lives and those types of things. So it can be the same person, and it often is, but sometimes family members will share the duties and different folks will serve in different capacities.
Okay, so what is the procedure for this? How do we go about establishing guardianship?
So it's something that's done in the probate court, and it's a petition. All starts with a petition. So in that petition, there needs to be facts that are alleged that are sufficient to show that that person is not able to make decisions for themselves. And there's a lot of protections that are included in this process, and that's because not everyone who goes through this process is a loving parent or a loving child who's trying to take care of their loved one. So we do have some protections in place. The first thing that happens is the probate court reviews the petition to determine whether or not they think that, it merits looking at, if it should go forward or not. And sometimes they'll reject it right there, and other times they'll accept it. If they accept it, they're going to do two things. They're going to appoint a court-appointed evaluator who is going to go out to the proposed ward, and that's the person you're seeking guardianship over, and give the court an opinion as to whether or not they think the person needs a guardianship. The other thing that the court is going to do is that they are going to appoint an attorney for the individual that someone is seeking guardianship over, unless they hire their own attorney. And the reason for that is we want to make sure that, there's someone there fighting for that person's rights. And if that proposed ward wants to fight it, then the duty of that court-appointed attorney is to fight it for them. The other thing that's going to happen is that there may be a guardian ad litem that is appointed. And a guardian ad litem is someone that looks out for the best interests of the ward. So the court-appointed attorney is advocating for the ward, but the guardian ad litem is someone who's actually telling the court, I think this is in their best interest, and kind of looking out for them as opposed to doing what they want them to do. And so after we get the evaluation and the court looks at the petition again and says, okay, we think that we should have a hearing on this, that it looks meritful, then at that point a hearing is set. And that hearing is basically a trial. And the petitioner, the person who's seeking the guardianship, then has to actually prove that this individual needs a guardianship. And that can look different. It sort of depends on whether or not someone's contesting it. Sometimes an interested family member could be contesting it. As part of the process and the protections, we do give two family members notice, other than the petitioners and other than the proposed ward, so that, it kind of, if there's a problem, it's a red flag, then hopefully those loved ones will contest it. So if it's contested, then it, can be, it can go on for days in some cases, but most of the time it's not contested and it is warranted, and it can be done in just a few minutes. So, and I say a few minutes, 15, 20 minutes.
Okay, this sounds like a really adversarial procedure, and I wouldn't have thought of that initially, especially if it's concerning a parent. But is it oftentimes that an adult child will seek guardianship against the parent's wishes?
So, yes, okay, so we have to understand the person no longer has capacity.
Mm-hmm.
And so sometimes that's because of a mental illness or a substance abuse issue that is very severe. Other times it's due to dementia, and so someone is really not in their right mind. So whereas years before, when then they were in a reasonable state, they might not have fought it, under those circumstances they might. And the other thing is, not everybody that does it for the right reasons. And not everybody not every petition should be granted. So sometimes there's a reason for a fight. So it can, it certainly can be confrontational. And there's also something important to know is there's no such thing as a consent guardianship. So you may know that in most litigation, the sides can get together and just agree. But in this particular instance, the person is deemed, the idea is that they're incapacitated. And if they're incapacitated, they can't agree to it. So there's no such thing as a consent guardianship.
Now, does that affect, like, if the siblings, okay, so you said there was a notice requirement for siblings. Does that also apply to whether siblings all consent that one person should be the guardian?
Well, let me clarify. Two family members have to be notified.
Okay.
And so it sort of depends.
So it's just limited to any two family
certainly
members?
the spouse and the children would have to be notified.
Okay.
And so the spouse and the children would have to be notified even if it's more than two, but at least two. And so if the person didn't have a spouse or children, then you kind of go through a list of folks that are outlined in the statute of who should be notified.
Okay. And back to that. If the spouse and the children agree that one person should be the guardian, does that affect the proceeding at all?
Well, it makes it a little bit easier, but they still have to go through and prove to the court that those rights have to be taken away, because in order to give someone else the rights to make those decisions, the rights have to be taken away from the proposed ward. And so we do have to always go through that hearing.
Okay. So what other type of long-term planning issues are we talking here?
Okay. So with long-term care, the very first question is, what exactly is long-term care, I think, for a lot of folks. And long-term care is most easily explained by what it isn't. So it isn't acute care. So, for example, if someone were to fall and break a hip, that would be acute care. And for that, you would go to the hospital for a certain period of time, and then you would get a certain amount of rehab, and then you're all better, and then that care ends. So it's for a limited period of time. And Medicare would most likely cover that. With long-term care, it's more a situation for debilitating diseases like dementia or Parkinson's disease. And long-term care is difficult to pay for because it's not covered by Medicare. Medicare will cover up to 100 days if there's a hospital stay and there's a number of other conditions that are met, and the sun and the moon and the stars align, I like to say. And even the last 80 days of that 100 days, there's a significant copay. So for the most part, Medicare doesn't cover that, and that also includes Medicare supplements, VA, the TRICARE, all of your Advantage plans, all those types of things don't cover long-term care. And so as a result of that, it can be difficult to be able to cover those costs. So that's where long-term care planning comes in.
Okay. We're up against the end of this segment again. Patricia, give them some contact information for you once again.
Absolutely. You can reach me at www.elderlawatlanta.com and also at 678-609-3230.
You're listening to Lewis on the Law. My name is James Lewis, and all my old shows are archived on my website. Go ahead and go to my website, and they're all on the podcast, and a lot of them are on my video blog. You can reach me at james@jameslewislegal.com. If you have a question and a topic that you'd like to hear on the show, go ahead and contact me. And if I can't answer your question, I'll bring an attorney on who actually knows something about your topic, and we'll talk about it. This show is designed to be your first step in the legal decision-making process. Basically, it's only designed to give you information. It might help you decide what type of attorney you're looking for, what kind of issues you need to deal with. It's not designed to replace the advice of an attorney. You're listening to Lewis on the Law. When we get back, we're going to talk more about long-term planning. You're listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week for fun, informative, and powerful, empowering sessions on the law. And who knew that you could make the law fun, huh, Patricia?
Oh, absolutely.
Yeah, I am honored to have attorney Patricia Ammari on with me from the Ammari Law Firm, or the Ammari Firm. Mm-hmm. And the Ammari Firm is actually one of our leading elder care firms. I mean, when I started talking about I needed an attorney for elder care, I got your name thrown at me from a couple of different sources, too.
Oh, wonderful. Thank you.
So that's pretty good. So
I appreciate that.
I usually don't get that. So we were talking about long-term planning. So hit me with some statistics. I know you've got some statistics for me.
I do. One of the reasons why it's so important that we're talking about this is that the Department of Health and Human Services has determined that of individuals turning 65 today, that almost 70% of them are going to need some sort of long-term care during their lifetime. So that's going to touch a lot of folks.
Wow. Okay. 70%. That is going to touch a lot of folks.
Absolutely. So when we're talking about planning for long-term care, we're talking about two different things. The main thing that we're talking about is planning to pay for it. And then the second thing that in some cases we're also able to talk about is preserving assets when possible. Because, folks are usually, they work very hard for their funds and they don't want to see everything gone at the end of their life. They want it to at least, be there for them. And a lot of times they want to pass things on to their family.
Yeah, planning for the financial part of it, that seems really difficult because there's no telling how long you're going to live or what type of finances you're going to need.
You're absolutely right. And when I'm talking with my clients and they're having to make decisions in all areas of long-term care, I always feel so bad for them because I feel like they're making the decisions with blinders on. If they
It
could
seems
tell
like
me
everybody would make
right,
decisions. I mean, who knows?
exactly. You have no idea, what your health is going to be like, over the course of your life. And even if you do have a diagnosis, you don't know how quickly you're going to progress through that process and whether or if you'll ever need long-term care. And so, when you're making these decisions, it's sort of like insurance. You're trying to put things in place so that you plan for the worst. You hope for the best and you plan for the worst. So when we're talking about the sources of payment, we've already kind of covered the fact that Medicare really doesn't do much when it comes to long-term care. So then, how do you pay for it? Well, a great way to pay for it for those that have it is long-term care insurance. And it can be expensive, but it can be so worthwhile. And also, there are new types of long-term care insurance out there. So, for example, some folks obtain their long-term care insurance as part of their life insurance, believe it or not, and it's a rider to their life insurance. And that insurance,
I've never even heard of long-term care insurance.
Mm-hmm. And what it does is it covers long-term care. So, someone coming into your home to care for you, assisted living, it depends on the policy. Nursing home care, you'd want it to cover all of those things.
Now, wait a minute. Is this a provision or a rider in all life insurance policies?
No.
Or just special life insurance policies?
No, just special life insurance policies. So you'd really want to work with your financial advisor to talk with them about, when you're looking at life insurance, to think about long-term care insurance and find out the different ways that you can insure yourself for long-term care, because it is an excellent thing to have, both because it pays for long-term care, but it also gives you more time in order to engage in some of the long-term care planning that we can do. So it has a lot of benefits. And, we had the old-fashioned use it or lose it policies, but now, we do have these hybrids that, are even more affordable and sometimes provide even better insurance. So
now that's a question I'd have to ask you about. How affordable is this long-term care planning?
So,
insurance.
Insurance, it depends on the policy. It definitely does. And it used to last forever, and now it's only 3 to 5 years generally. So the policies have changed a lot. Insurance companies were shocked to learn how much folks were actually using these policies, and a lot of insurance carriers have gotten out of the business as a result of that. So, but it's definitely worth it to look into, and if you can afford it, I recommend it. Another way of paying for long-term care is private pay, and that means just out of pocket, and that's how a lot of long-term care is paid for. However, there are a couple of other benefits that can be of assistance. One is Medicaid. Now, Medicaid doesn't apply to assisted living, but it will help significantly with nursing home care for those that qualify, and I do assist folks in getting qualified for Medicaid, nursing home Medicaid. And then another option is the VA. So for folks that served during wartime, then there may be a benefit depending on their dates of service that can provide a benefit. It's a much more limited benefit, but it can still be helpful for folks, and that can go toward assisted living care.
Okay, so earlier you said 18 years old people should actually start looking into some of these issues. Is that realistic? I mean, how early do you have to be to really start looking into your long-term healthcare planning?
So usually financial planners that I've talked to recommend beginning to look at long-term care insurance in your 50s. So the powers of attorney and advance directive, you do want to get in place, once you're 18. Mm-hmm. But as far as long-term care insurance, that's something you're going to look at a little bit later. By doing it in your 50s, I'm told that it brings the cost down. So that's, one of the reasons why you would look into it. And unfortunately, I have had some clients who have needed long-term care in their 60s due to falls and unexpected circumstances. So one of which who had decided not to get long-term care insurance just a very short period before the accident happened. But when I'm helping folks with long-term care planning, I'm typically looking at folks in 3 different stages. The first stage is pre-planning. So these are folks that are not going to need nursing care and long-term care for 5 or more years out. And there's some fancy things that we can do with trusts and whatnot for those folks to protect assets. But I'm going to devote most of my time talking to the rest of the folks who are most of the folks that I deal with, and those are folks that either are needing nursing home care immediately or they're going to need it within the next 5 years because there's been a diagnosis. So it's a common scenario where a couple will come in, one of them has been diagnosed with dementia, one of them, the well spouse, is worried about being able to make sure their loved one is taken care of and at the same time not end up in the poorhouse. And so for those folks, I do something called a long-term care planning report, which kind of gives them an analysis as to where they are in the process. And one of the very most important things to do, particularly when there's been a diagnosis, but to allow the door to be open to long-term care planning, is to have a power of attorney that has elder care provisions in it. And to get that, you really do need to see an elder law attorney. The estate planning you're going to get from a regular estate planning attorney and the estate planning you're going to get from an elder care attorney are going to be very different.
Okay, so bringing up diagnosis, if a person has a diagnosis like dementia or cancer and it's going to affect their long-term planning, of course, are they still eligible for long-term care insurance? Is that still going to be an option for them?
Once you've had the diagnosis, it's difficult.
Okay.
And I don't handle the underwriting or the policies, so I would still recommend that you talk to your financial advisor. I'm told that, some carriers will allow certain things, other carriers will allow other things. So sometimes there's some room there, but I would recommend, speaking with a professional that deals with those policies. But, most likely the door will be closed at that point, but not always.
Okay, so starting early does make the difference then.
Well, it does, because you have to get that policy before any of these conditions pop up.
Okay. So, Matt, what if I'm a person who wants to avoid guardianship or conservatorship? Are there steps I can take?
Absolutely. So one of the best things to do is get a power of attorney in place and an advance directive. And what those documents do is it already puts someone in place to be able to take care of you. And when the court is actually mandated by the legislature not that they have to use the least restricted method of helping a person with incapacity. So, for example, if there's a power of attorney in place, or even better, a revocable living trust that's managing that property, there's not a need for the conservatorship in most cases. Now, sometimes there's something that needs to be done that's not listed in the power of attorney, and in that case, there might need to be a conservatorship anyway. But most of the time, a power of attorney or a revocable living trust will avoid the need for that. And then on the healthcare side, the advance directive, putting that in place can alleviate the need for a guardian. Now, sometimes if there's something that needs to be done, like if there's an individual who has dementia and they're wandering into traffic, and they need to be placed in a facility for their own good in order to keep them safe, that is not going to be something that an advance directive can accomplish for you. So in that circumstance, you might still have to go through the guardianship process. But in the absence of that extreme circumstance, having that advance directive in place very well may be sufficient to avoid that guardianship.
Yeah, I can imagine a person being very upset. I can imagine a cantankerous old person, even if they're going through dementia, saying, I don't want guardianship or conservatorship.
Absolutely, absolutely. So this is a way of you getting to do two things. One, you're putting someone in place so that you will hopefully avoid the need for it altogether. But in those documents, we also list out who you would want to be your guardian, who you would want to be your conservator. So you're getting still a little bit of extra control, so that if it does happen, that at least it may be the person that you name. The court won't just do it because they have to make sure that this person is appropriate to serve. So for example, if you named your daughter and your daughter has since become a drug addict, she's probably not the right person to be there.
I wouldn't think so.
So we still have to go through that process, but if everything is okay and you've named this person, then the court will likely honor your wishes and are required to do so.
Okay, Patricia, we're up against the end of this segment again. Give them some contact information for you once more.
Absolutely. You can reach me at www.elderlawatlanta.com, and the telephone number is 678-609-3230.
You're listening to Lewis on the Law. My name is James Lewis, and if you have a topic you'd like to hear on this show, go to my website, go to the last page, the contact page. You can just drop me a line and a quick little bit of information on the topic you'd like to. I'll get back to you. We'll talk about it, and then if I can't talk about your topic, I'll bring on an attorney who actually knows something about your topic, and we'll get into the issue on air. This show is not designed to replace the advice of an attorney. This show is designed only to give you information. It's designed to be your first step in a legal process, telling you what you may want to look out for, what you may not want to look out for, what type of issues are at hand, what type of attorney you might want in your corner. You're listening to Lewis on the Law. When we get back, we're going to kind of wrap up where we've been, and then we're going to take a look at special needs planning. You're listening to Lewis on the Law, and I call what we're just listening to hippie music. I guess that's part of my generation, but I have just been told by our younger producer that that's not really hippie music, that I don't really know what I'm talking about, that there's a new term for it. I think he called it tiki or something like that. I'm like, can't keep up. Kids these days, who can keep up with them? I mean, kids, what do you know? I am on the air with Patricia Ammari, attorney Patricia Ammari of the Ammari firm, and I'm glad to have you here. I've heard you spoken about very highly, very highly.
Thank you so much.
Yeah, once more, give them some contact information for you and a little bit about what your firm does.
Absolutely. So the contact information is www.elderlawatlanta.com, and the telephone number is 678-609-3230. And the Ammari firm is a full-service elder and special needs law firm. So we help folks with estate planning, guardianship and conservatorship, estate planning, probate, long-term care planning, and special needs planning.
Okay, now let's go back through. I'm going to call this the toolbox, if you will. What are the toolboxes? What are the tools here that you use to help someone plan for their elder years, their aging years?
Absolutely. So we've been speaking about estate planning, which includes a will or revocable living trust and a financial power of attorney and an advance directive. And then we spoke a little bit about guardianship and conservatorship, which is appropriate when a loved one is no longer able to make reasonable, responsible decisions about health and safety or about their finances.
Okay, and let's go really quickly or touch on the procedure to put guardianship in place or conservatorship.
Absolutely. So the first part of that is to file a petition with the court. The court will review it, and if they think it's appropriate, then they will send out a court-appointed evaluator to the ward, proposed ward, the person over which someone is seeking guardianship. And they're also going to appoint an attorney for that person so that if that proposed ward wants to fight it, that they'll be able to do so. The next step is that the court will review that report and, again, look at everything and determine if they think it's appropriate to move forward to the hearing stage. And if they do, then they'll hold a hearing, which is a mini trial, to determine whether or not that individual no longer has the ability to make reasonable, significant decisions for themselves.
Okay, are these hearings extremely adversarial in nature?
They can be.
Okay.
They can be. And they can actually go on for hours or possibly even days, depending on how contested it is. But if it's not contested, it's usually a relatively quick and painless situation.
Okay, say someone is getting older. What do you think is the most important of these provisions or tools to have for a person who's growing older? Is there just one that's more important? I'd say you want to save money.
So I guess the very, very most important thing is probably the power of attorney and the advance directive, because those documents are going to take care of the individual during their lifetime. So they may say, well, I'll be gone when, and when it's time to deal with their property with respect to a will or revocable living trust. But, certainly that power of attorney and advance directive are going to be with them during lifetime. And so those are really important. Plus, they set the stage to being able to do other planning for them to help take care of them with long-term care planning.
And do you think that's more important than a will?
They're all important, but I do sort of think that they are more important because you're going to be dead and gone when it comes time to the for the will. But and it sort of depends on the circumstances. If you have children that you have to take care of, then yes, the will is very, very important and maybe the very most important thing. And also, if you have a family member with a disability that you're taking care of. It's even more important under those circumstances. But otherwise, I think the power of attorney and advance directive that actually service you during your lifetime may be even more important.
Okay, so I think you kind of touched on something that we're going to get into. I mean, if you have a child with a disability, are there differences in planning for people with special needs?
There are. So one thing is that when everyone turns 18, magically they're considered an adult and able to make their own decisions. And, as parents, we kind of chuckle about that, and, whether that's appropriate. But for folks who have children with a disability, that can be a real problem because they've always made those decisions. That child is not able to make those decisions. But in the law, the parent no longer has the ability to do that any longer. So they have to go through that guardianship and conservatorship process that we talked about. So that's one piece of special needs planning.
Wait a minute. So if there's no one who can actually be a guardian to that special needs child, what happens if there's no aunt or uncle or person that's willing to become the guardian of the special needs child? What happens at that point? Just
so the state might have to step in under those circumstances.
Oh, okay. Never mind. Let's go on. That's kind of sad. But I was just wondering
that's a terrible scenario.
Yeah, when you just said that, I thought, what happens when there's no one in place to deal with those issues?
If the parents have done some planning, then actually they have put some things in place for that child. So, for example, if someone has a disability, then it is a big possibility that they may also be receiving either Social Security disability insurance or what we call SSI. And SSI comes with Medicaid, which is health insurance, and it is something that provides some income to that individual, but also, most importantly, their health care. It pays for their health care insurance. And so as a result of that, as a parent of a child with a disability, you don't want to leave money directly to your child, because if you do, you are then jeopardizing their ability to keep that health insurance. So
wait a minute, you're jeopardizing their ability to keep the health insurance if you leave money directly to them? Why is that?
That's correct, because SSI and then Medicaid are what we call means-tested benefits. So you have to qualify financially in order to continue to receive them. And when you receive an inheritance, that can cause you to lose your health care. And for some folks, the services that they receive can only be received through Medicaid. And but the government, has thought about this, and they really want families and government to work together. So they've created a system, a partnership basically, where it allows a family member to leave assets to a disabled person in something that we refer to as a special needs trust. Sometimes it's referred to as a supplemental needs trust. The purpose of this trust is not to take away benefits or supplant benefits, the magic language. It's instead to supplement those benefits. And so it won't cover the things that the state is providing, but it can cover additional things for them. So things that make them happy, like cable and, and a television set, and games and, different things, possibly travel, things that are going to bring their happiness, into play. And so by having this trust set up, all of a sudden you're able to provide for your child. And these trusts have all these provisions about, being able to employ care managers. And there's a trustee, and that trustee's responsibility is to make sure this child is being taken care of and that the funds are being expended properly to make sure this child has everything that they need. And so by putting these things in place, you put in this whole, network of support for this child. And I refer to it as a child, the person could be, it's their child. It could be a 6-year-old child, but for their child. And that's so important for parents who do have a child with a disability, because one of their greatest fears is what happens when I'm no longer here, such as in the scenario that you just mentioned. So if all of a sudden there are all these assets to take care of this child, then there will be someone there for that child. And if there are significant enough assets, you can even have a bank be a trustee.
Okay.
So there will always be someone that can look after your child.
So what if there is not significant assets, and what if the child runs out of money prior to that? Is there anything that can be done?
So first of all, I would recommend life insurance and talking with a financial planner. So there's one that I work with that has a deep understanding of special needs and has gone through all sorts of education in order to be able to serve those families well. And, he can talk with the family about self-funding the care for their child, or alternatively, obtaining life insurance that can then pay in directly into the trust and then take care of the child that way. So there are ways to make sure that that doesn't happen.
Okay. So talking about trust, what type of trusts are there that we can set up?
Okay. So there are a couple of different types of trusts when it comes to special needs. There's something called a first-party special needs trust, and that is a trust for the assets of the person with a disability. So, for example, if someone were to have already left assets to that individual and it came to them directly, then they can put their assets in this special type of special needs trust, and then it will not count against them for benefit purposes. Now, this particular type of trust where it has already come into their hands has a significant downside, and that is that Medicaid has to be paid back at the end of their life before it can pay out to any of the other beneficiaries. And so that kind of brings in the third-party special needs trust. And this third-party special needs trust doesn't have that payback provision in it because it's someone else's assets. So in other words, the parents. So the parents can set up such a trust now for their child that grandparents can leave money into, aunts and uncles can leave money into, or gift money into to take care of that child one day. So it can kind of be, it takes a village sort of situation so that that money is never directly inherited by the person with the disability and affect their benefits and have to do that first party special needs trust. And so this third party special needs trust is other people's money, and therefore there is no Medicaid payback on that. And so it gives a certain amount of flexibility there, and it allows others to contribute it to it as well. The first party trust can only be one person.
Patricia, you have given us a lot of great information, and time flies when you're having fun. And who knew the law could be fun, right?
Absolutely.
Absolutely.
For us law geeks, it is.
Yeah, exactly. So why don't you give them some contact information for you once again?
Absolutely. It's www.elderlawatlanta.com, and the telephone number is 678-609-3230.
You're listening to Lewis on the Law. I have delivered yet another great show for you guys. Great if I do say so myself, and I hope you think so too, Patricia. It was an honor to have you on.
Thank you.
Next week, we are going to talk about taxation in real estate transactions. You're listening to Lewis on the Law.